Mr. Smith, the reason we're having this hearing is because there was some orders that Mr. Smith requested that had to do, I guess, with some pension plans. So when so you sent something, you sent some documents in, and when you got them, the documents had accepted stamped up at the upper right-hand corner in red. When I just assumed that accepted meant that you were that you were okay with me signing those documents. So was I mistaken in some way?
Assume is the key word there. Y'all do a lot of assuming in those courts. This was
it has a signature on it too, Judge.
Yeah, well, Mr. Smith, instead of yelling at me about what I did, I'm giving you the opportunity to explain so I can fix this if possible. So what do you want to do?
Please. Okay. I sent you a non-negotiable notice of approval with stipulations. The 4 stipulations were that I do not argue venue, I do not argue jurisdiction, I do not argue law, or I do not argue facts. I am recognizing your jurisdiction, and I'm recognizing my requirement to answer, and my remedy was to be in equity, and it was there. I asked for, let me see what I asked for. Requested an appearance bond.
No.
I requested.
Okay. Go ahead. I'm sorry. I didn't mean to interrupt. I was wrong.
If you have it before you, I requested an issue of an appearance bond. I requested you close the account and issue the order of the court to me. I request you adjust and set off the public charges, and I request discharge. That is the proper way to discharge my debt. And I gave you 3 days to respond. You didn't. Whenever I talked to Ms. Vargas days or weeks later and explained what this was, that it needed to be addressed, they were still more than 3 days lapsed. So in my opinion, you are in dishonor. That's what it says down here. You may, if you do not comply, you may be in dishonor.
I don't know what that means. What's dishonor mean?
If I am in dishonor of the court, I can have a warrant against me. If you're in dishonor of the whole procedure, then you have acquiesced to my demand or my request. And that was those 4 requests, that you discharge this, get my name out of the controversy, and take whatever you need out of my account. That's the procedure.
Where are you getting this procedure, though? I'm required to follow the Texas Family Code and the Texas Rules of Civil Procedure, but none of that sounds vaguely familiar. I might have been asleep that day in law school, but this doesn't sound like what we typically do in Texas. But go ahead and explain to me where this is all coming from.
This is equity jurisprudence. It follows equity. Well, I give equity, I receive equity. I'm giving you the equity of not challenging you. I want you to have the jurisdiction completely. I want to accept completely my need to discharge this case. And I'm asking you,
what do you want me to, Mr. Smith, what do you want me to do? I'm not sure. You say that the facts are not in dispute. The law is not in dispute. That, in my mind, means that you're basically okay with Mr. Smith's request. Well, I don't know what you want me to do.
To discharge the case, I want you to set off and adjust the public charges and the private side, both sides. I want it discharged. That means that.
Well, explain to me what discharge means, because you're not really talking a procedure that I'm familiar with.
Well, then I am allowed a judge that does understand equity jurisprudence.
Well, no, just cite me the rule, cite me the authority, the legal authority, and like I said, if I'm wrong, I'm the first one to admit it, and I'm willing to fix it. But I don't know, and you're just confusing me a little bit. So look, are you citing some authority somewhere, a written authority? I mean, the Texas Constitution, the U.S. Constitution, what exactly?
I am in equity. I am not using any statutes. I'm not using any historical, anything that backs up what I'm doing. I am asking you equitably give me a remedy for this situation.
Okay, well, wouldn't a remedy be that I just sign the order so that you no longer have any obligation to her and she doesn't have an obligation to you? Wouldn't that be equitable?
Is your idea that I sign over my retirement funds to her? Is that in your part of the understanding?
I don't know anything about the facts of the case. I don't know. I'm just asking you. I'm not, Mr. Smith, we're in two different worlds. I think you're just going to have to, I'm going to take this as a motion for new trial. I'm going to deny the motion for new trial, and then you can kind of proceed, accordingly after that. I mean, you can appeal it, which is okay with me. I mean,
what is, may I ask you your name?
Randy Shelton.
And Randy, what is your EIN number?
EIN number? What is an EIN? What are you talking about? I mean, what does EIN stand for? Employer's identification number?
Exactly, sir. You are working for the bank. You have an EIN number?
No, I don't work for the bank, Mr. Smith. Maybe that's why we're having so much confusion. I'm the judge in the case. I don't work for the bank.
You're denying me my remedy.
Look,
I have a remedy. I have a remedy in equity. And when you deny remedy and equity because you don't understand it, you are liable. You are liable with your bond. You are denying my remedy. You do not understand.
Mr. Smith, I don't have a bond. I don't think I have a bond. I mean, I don't think judges in Texas are required to have a bond. So, are you in Texas, or are you in another state? I'm thinking maybe in other states they do this, but that doesn't sound like the procedure in Texas. Well, are you in another state, maybe?
No.
Okay, you're in Texas. Okay, I don't know what procedure you're following, Mr. Smith. I mean, if it's kind of a common law thing.
It is very close to common law. It is very close to common law. All laws are based on this equity that I'm speaking of. Just people don't use it. They don't go for equity. They fight it. They fight cases. They use old cases. All I'm asking is for you to provide what only you can provide is a discharge of the case with my provision of my account that you can tap. You have my Social Security.
But didn't I tap your account, sign that order, and split that pension? Didn't I do that?
I don't understand what you said. When you split what?
All right. You said you said something, I think, about me splitting the account. Isn't that what you said?
No, to set off the account, to adjust it to zero, balance the account.
Okay. I gave her what I understand was her part, and I gave you what I understood to be your part. Didn't that resolve it? I mean, I didn't award a judgment in favor of anybody. Judgments are legal. I think dividing assets, isn't that kind of equity?
I am asking for equity to use banking rules, charts, and offset a financial account. These are all accounts.
Okay.
This is all marketing.
I
understand.
Mr. Smith, let's just agree that we'll have to agree to disagree, because I'm not really following you. And it's probably me, honestly. But I'll tell you what, I without raising my voice or anything like that, I'm just going to I will interpret this to be a motion for new trial. I'm going to deny the motion for new trial based on what you're telling me, and now the time will start for you to go ahead and file an appeal with the Court of Appeals, so if you so choose. Okay, so like I said, I don't think you can. From what you've told me so far, I don't think you can really talk me, out of that, because I'm not sure. Maybe when you do your brief to the Court of Appeals, you can elaborate in writing much more, and then maybe they can see the point that you're trying to make. And then if they send it back to me, it's okay. I won't be mad. And then at that point, I'll try to and consider reconsider what I need to do. But I don't. You're probably way over my head on this, and so that's what we're going to do. So I'm going to go. So just be on notice that you've got 30 days to appeal me. Okay?
If it's true that I'm over your head, you're sinking deeper and deeper by denying my motion.
Hopefully I'll survive.
I am going to take another course here. I want to file a motion to amend.
Okay.
And rescind my signature.
Okay.
From what said that I was going to do. So I need to talk to Miss Vargas and find out if she has a. Well,
no. What did you? I don't think there's anything that she can do for you. I think, Mr. Vargas, Mr. Smith, you're just going to have to file a motion for new trial with the Court of Appeals, and then we can take it from there, because honestly, I'm not exactly sure what you're asking for. Okay. I think you're citing a body of law that really that I generally do not apply, in these type of cases. Okay.
It does not apply. The law does not apply here. This is equity.
Okay.
I'm asking for a remedy, and I'm being denied my remedy. I've given you a perfectly good remedy, and all you have to do, balance the books.
Okay. Well, what if I just deny the remedy that you're recommending? Would that settle it?
By denying my remedy, you are denying it again.
I'm denying the. This is going on way too long, and I'm not making any progress. I think we all agree. So, look, Mr. Smith, I'm really trying to fix this for you, but I apparently I can't. So I'm gonna let you go. File your motion for appeal within 30 days. There's no reason to call Miss Vargas back, because right now your case would be in the hands of the Court of Appeals if you appeal. Okay. And if I'm wrong, I'll tell you. And if they tell me I'm wrong, I'll come back and tell you that I was wrong. Okay? I'm going to go ahead and... What?
Is this a court of record?
Yeah. You took a record, didn't you, Elisa? Yep.
Okay.
Got a record. You're all set. You got everything you need, I think.
Ask, is this on the record? Is this recorded?
I just told you yes.
Okay. That's good. That's all I need.
All right.
Thank you.